Hi everybody, Charley Egan here of the Egan Group at Hall & Chambers Real Estate. And this is one of a series of ongoing videos that I do with my trusted providers and vendors that I refer out to you homeowners and buyers and sellers and friends and family of my clients. I'm so glad to have Sona in here today. She focuses on estate planning, trusts, and wills. And she's going to talk today on a very, very important topic about how a parent can pass on the real estate holdings to a family member or a child, and all the different hurdles you have to go through and the challenges around that. So Sona.
Thanks for having me, Charlie.
Oh, it's so wonderful to have you here.
Thank you, thank you. So we've had discussion for a while, and I see a lot of issues where a parent wants to transfer title to a child, and what are the consequences that could follow from it. So let me give you an example. The example we'll use would be a widow who has purchased a property, let's say with her spouse, in the 70s in our local area, and the properties during that time would be, let's say, going for about $100,000. And today, as you can imagine, after 40 plus years, the value of the property has gone up significantly. So let's use an example of $1 million. And this is a very common example that happens. So
when the other spouse passed, they got a stepped up basis, or that doesn't even factor
into
this?
That doesn't even factor into
this.
this. So what I'm imagining is a widow that comes to my office and says, I have an only child, I have a son. Why do I have to wait until I pass away? I just want to give him my property now. So what does that look like? And can I just file a quit claim deed and just give it to my son? And what are the repercussions that follow from it? So I've identified 4 issues that we could talk about. Right. And the first one would be what's called step up in basis, right? Step up in basis is when if the mom was to pass away and if she was to give the property to her son at her passing, the son would get the property at a step-up basis, and that would be her date of death. So let's say if she was to give the property today and right after she passed, that he would inherit it at $1 million. He sells it, he doesn't have to pay capital gains taxes. But if she was to do a quit claim deed and give the property to him right now, if the son wants to in the future sell the property, he has received the property at the carryover basis, whatever the mom paid for it. So if the mom paid $100,000, the son has paid $100,000 for it, and if he sells it for $1 million, he will pay capital gains taxes on the $900,000 gain.
Sure, that's huge.
And that's a common thing that parents will do. They will sign the quit claim and then they'll think about it, not knowing that the child could face significant tax issues down the road.
Sure. Yes.
Another thing to think about whenever a parent transfers property to a child is you want to make sure you're filing the appropriate paperwork with the assessor's office. Because what happens is you want to make sure the child receives that parent-child exclusion that's allowable under the assessor's office.
So it doesn't trigger a reassessment.
Correct.
Yeah.
So what happens is when you inherit property from a parent, you can get a very high valued property, but you pay property taxes at the same level your parents are paying. So that's a really good gift that you can give your children.
Sure.
And no matter the value of your primary home, it could be a $100,000 home or a $5 million home. For the primary home to pass to the child, they could always pay at the same tax rate that the parent was paying.
Yeah.
So another thing to think about is gift taxes. So when someone quit claims property to their child, is they're in essence making a gift, and they need to let the IRS know that they've made this gift. Otherwise, consequences can follow from it. So you may not necessarily, the widow may not necessarily end up paying gift taxes, but she needs to file a certain tax returns, a gift tax return with the IRS to let them know that she has a lifetime exclusion of $5.49 million. That's the current value.
That's the current value.
And she's deciding to use some of it. So when she passes, she will use less of those, less of the amount that's allowed to her. But that's a big consequence that could follow. You're making a gift. You're not just transferring things on paper. You're making a significant gift, and you need to file the appropriate paperwork for it.
The $5 million that's the current rate, or five.
5.49,
Okay,
correct.
okay.
And that goes up based on cost of living adjustment. So
Okay.
every year, it's been going up. So at one point it was 5, and now every year it's creeping up a little bit.
Got it, okay, good.
Yeah.
You were going to talk also about the parent perhaps losing control, or sort of the family dynamics as well, should be
Sure.
addressed or talked.
Sure, and that's really, people don't think about it. Their home could be their largest asset. And let's say the widow gives her son, her only son, the house, but he says, Mom, you can stay at the house as long as you want.
Sure.
If he was to marry someone and the wife says, we should sell that house and buy a bigger house for us, she's all of a sudden lost all control and over what she can do with the property. So a lot of people think this will not happen to them. But you never know. You don't want to necessarily give your largest asset away now. She may need the home down the road. If she was to sell it, she could use it for her own long-term care or anything else that she needs it for. So if once she gives it up, she gives it up. So there's a psychological benefit to you retaining control and retaining the house. So the best thing to do would be to place the home in a revocable trust that the mom continues to control while she's alive.
Oh, after.
Correct. And
Okay.
she will give the property to the son after he passes.
I see.
After she passes,
After she
I'm sorry.
passes,
Correct,
yeah.
yes.
But the stepped-up basis has already been, or the basis will not change, because it's what the mother paid for it.
So when the mom puts the property in the trust, she's
Yeah.
still 100% owner of the property. She has not given the property to the son. The son will inherit the property only after she passes,
Okay.
and he will get the step-up death
Okay.
to the date of death value.
Yeah.
So the benefit of putting the home in the trust, you get the step-up value as of date of death. So the son will get $1 million property at $1 million basis. If he was to sell it, there's no capital gains taxes.
Yeah.
But if he decides to keep the property, he also can file for the parent-child exclusion and have $1 million home that he's paying for very little in taxes, because he's still paying taxes as of the mom, as if the mom was paying them.
That sounds like probably the best solution.
Absolutely.
Yeah, yes.
Absolutely.
Wonderful. Well, any other final notes on this topic that you?
I think we discussed the important ones, but my concern always is to proceed with caution, talk to a professional. Don't just sign a quit claim, file it, and then deal with the consequences. Actually talk to someone and figure out what is the best option for you. Sometimes giving a gift during your lifetime may be the best option, but I think it's good for you to talk to a professional, to know what your options are, to know what the tax consequences are, and then proceed knowing what the results would be.
Yes. And a good estate planning attorney will take you through those things. And Sona is here local, and she's a great estate planning attorney. And her information will be linked to this video, so you can reach out to her if you have any questions. Sona, thank you so much for coming in.
Thank you, Charlie. Thanks for having me. This
All right.
was lovely.
Thank you all for visiting, and there'll be more videos on their way. Take care. Bye-bye.
Bye.